So, ladies and gentlemen and students, the next question that we must address is a public private partnership a joint venture? Is it a joint venture? Now, you must be saying, who is the joint venture here? Is it public and private together? The answer is absolutely yes. Is it a kind of partnership? Probably we'll answer it in a little while, because here is where probably the law on organizations becomes very critical and important. But the point is that joint ventures in India have been existing for quite some time, and we have seen that post the 1991 liberalization era, where we allowed foreign direct investment to come into this country, foreign companies to do business in this country, but we allowed them in a very staged manner. In some cases, the FDI was allowed just 49%, later it was increased to 74%. In some sectors, now we have 100% FDI that can actually float. Joint ventures in India are very important because it's an important form of commercial and business ventures. And you will notice that probably some of the initial joint ventures were on high technology contracts. We could think of, say, companies like Hero Honda, Kawasaki Bajaj. All of these were kind of technology joint ventures because the technology was not in India. Say Hero wanted to tie up with Honda and they wanted this technology to make two-wheelers. Initially, you will notice that we had two-stroke engines, then we went into four-stroke engines. We developed that kind of technology. So technology had to be brought to this country, and one of the best mechanisms of getting this technology is through a joint venture or a collaborative technology partner into this country, where the branding and royalty is shared with the technology partner, right? So then you had joint ventures in the product space, where you had companies like Mahindra trying to bring a product called Renault, with a company called Renault trying to get a product like Logan, or what we call as the car called Verito. So this was a joint venture just for the product. It was specific to the Indian market between two automobile manufacturing companies. One is Indian, the other is foreign. Mahindra and Renault coming for this product called Logan, right? Now, product joint ventures are also quite popular in this country. So, two companies coming together. Of course, it's based on the sales. It is based on commercial launch of these products and the kind of money that they make. That the royalties are shared between the joint venture partners. Then you have joint ventures that are equity joint ventures. This is the most important one because these are in terms of a shareholding pattern, and most of the equity joint ventures are kind of incorporated joint ventures, right? Now, technology and product joint ventures may be unincorporated. Incorporated means that two companies come together and create a third entity, right? So the incorporated joint ventures, when they create a third entity through a special purpose vehicle, that incorporated joint venture could be in the form of, say, actually a partnership. Please note, it could be a partnership under the 1932 Act. We know in India there are two laws on partnership. One is the unlimited joint and several liability partnership under the 1932 Partnership Act, which is a British law. Then we decided that we wanted limited partnership law, and that's why we brought what is known as the LLP Act of 2008. So you can incorporate it under the LLP Act because the 1932 law definitely has its own problems or shares of legal risks and liabilities. So I don't think joint ventures will ever go under the 1932 law because for simply the unlimited liability and the joint and several liability principles, which will actually make one person extremely liable for the other person, and that liability is not only limited to the capital that is contributed, the liability is also extending to his personal liability. So no company would want that unlimited liability model. So LLP is one form of incorporation that can be done, but it's not something that is favored by joint ventures. The joint ventures usually go to the private limited company model, which is under the Companies Act of 2013. They may make it public limited, but not public listed though. So incorporation is one way in which joint ventures are created, and private limited company model is quite a considered to be quite a interesting model. And you will notice that they bring in equity. Now, equity here could be, say, one partner holding 49% of equity and the other person holding 51, just giving the 51% a majority kind of a stake. Now, incorporated PPP models are existing in India. The Hyderabad International Airport is an interesting model of incorporated public-private partnership model. PPP models can be completely unincorporated as well. they will be what we call as the contractual based model as well, right? So the recent airports that are given to the Adanis could be the contractual based public private partnership model, right? They're not necessarily to be incorporated into a third entity. That's not a necessary creation that has to be done, right? I'm just giving you an instance or an example of an unincorporated JV. It is purely run through a contract, right? So that's kind of how the joint ventures in the public-private partnership mode can be. It can be purely contractual, or it could be incorporated joint venture where the government is involved. I'll give you an example of the same in the next slide. And what is also important is that you have joint ventures in tendering as well. So you will have joint ventures as consortium bids. Right, consortium bid is where two or more persons actually club together to fulfill the tender condition and submit a joint bid. This is called the consortium bid. It could be two or more. Remember that. Now, consortium bids are based on government's discretion whether they accept it or not. They can probably say no, we don't accept consortium bids, or they may say consortium of bidders can also participate in the tender notification. This is something that the government will have to make a conscious decisions about. Now, why do two or more companies submit consortium bid? It's for the simple reason is that the tender conditions are such that one company cannot fulfill the tender conditions, and hence they want to tie up with another company which could partially fulfill those tender conditions, and hence both of them could actually take the tender. They can actually participate in the competitive. If selected, both of them will actually put in their expertise to complete the project. Right. So that's how consortium bid becomes very important. Also, there are advantages of consortium bid. It's not about only just getting the technology or getting the expertise of two or more companies to fulfill the same. It's about sharing of the profits and the risks also. Because the project is of such magnitude and scale, running into so many thousands of crores, that one company may not be wanting to expose its own risk to that kind of a project. Right, so tying up with other company is like sharing of that risk as well, and sharing of that kind of capital that would be required to complete the project. So consortium bids have its advantages. Of course, they have the disadvantages as well, because what happens in consortium bid is that the consortium of bidders must have an agreement between themselves, and hence the tender conditions are very clear. That you will notice that the joint venture agreement of the consortium bidders must be submitted before they can be selected. So there should be a complete understanding between these two partners before they can submit that consortium bid as well. Because interesting difference, what happens is sometimes during the term of the tender or during the term of the execution of the government contract, one of the players may want to come out. Can he exit? Usually, yes, exit clauses are provided for. How can he exit? Can he sell his shares to some third party with whom the existing partner is not aligned or is comfortable with? Or should he sell his shares to the existing partners first? So, all of these will be relevant to bring in the liability, because remember, the courts have gone on to say that in consortium with the principles of liability, because this is like a partnership, though not registered or though not incorporated. And hence, when he looks at what is known as implied or express kind of an agreement between two or more persons to come together, please note it is nothing but a partnership that is created. Now, under the 1932 law, partnership registration is optional. It's not something that you can mandate it or make it very, very compulsory. And hence, anything that is not incorporated or registered but is an agreement between two or more persons, the partnership is almost like implied. It is something that can be inferred, and the courts have gone on to say that between the partners in a consortium bid, the joint and several liability principle will be applicable. Joint, that both of them are joint, and several, to the extent of their capital contribution, to the extent of their role, it is several as well, but it is unlimited. Joint, several, and unlimited liability is the principle that will be applied in the consortium bid space. Of course, in case of joint ventures that need some time for incorporation, because remember, there is always a gestation time between what is agreed and how you will probably execute it. Generally, in case of equity joint ventures, they enter into what we call as not only the joint venture agreement, which is the basis of two partners coming together. Based on a joint venture agreement, if they want to actually further incorporate and take the equity forward, generally they would enter into what is known as a shareholders agreement. Right, so two or more partners who hold the shares in that kind of JV come together and hold a shareholders agreement. How do shareholders manage their shares in the company? Who will put in what shares? How will the shareholders agreement be taken forward into what we call as the Articles of Association, which is the incorporating document in a private limited company model, right? So in incorporated JVs, first there will be a JV agreement, second stage there will be a shareholders agreement, and the third stage will be the Articles of Association that will be registered under the private limited company model. Generally, more or less, the shareholders agreements clauses go and get incorporated in the articles, but not necessarily so. But that's the basis of registration of the Articles of Association in a private limited company. Of course, joint venture partners will also execute a non-disclosure agreement or a confidentiality clause or a confidentiality agreement, because during that joint venture, before it is incorporated, there will be so many proprietary information that is shared. There is so many confidential data that will be shared, so many economic and financial data that will have to be exchanged between the parties, so that you will go forward, and hence confidentiality becomes critical between the partners, and that could be part of the JV agreement, or it could be a separate agreement even before the negotiations for JV start. So that's also something that is complied with as well. And even in a PPP project, friends, you will notice that confidentiality is very, very important, because government information is to be held as confidential information, as top secret sometimes, especially in critical infrastructure projects as well, right? Exclusivity. Now, this is also very important, because of the simple reason is that when you are tying up with someone, you don't expect that someone to actually go and tie up with some kind of competitor. So, exclusivity between the joint venture partners is something that needs to be agreed to. It needs to be executed and implemented as well. So, the joint venture partners have business of exclusivity between themselves. For example, we have seen in the McDonald's joint venture case how exclusivity important, because you don't expect the other JV partner to go and sign up with, say, Subway or Pizza Hut or someone else that is kind of a competitor in the food chain or food supply business. Of course, before a joint venture can come into existence, due diligence from both the partners is very, very essential condition. You need to understand. Now, please note, when the public or the government is trying to tie up with a private player, due diligence is compulsory. It is mandatory. You need to know what this company is. You need to know who the promoters are. You need to know what the balance sheet is. You need to know the physical and financial capacity of this company to actually come into existence and to execute this project. So, unless you do due diligence, and that is something that was very visible in the 2G case, when the Ministry of Telecommunications granted the 2G license to so many companies that actually did not have any kind of business with the telecommunication networks. So, the ministry itself, while giving that license agreement, had not complied with due diligence. This is something that we have seen in government very often, that once you have participated in the tender and you have become the L1, or like in the 2G case, what we call as the first come first serve policy, right? Everybody who applied got the license without any due diligence that was complied with. And interestingly, in some cases you will notice that you would end up giving license to shell companies. So I think due diligence is very, very critical. I think it is mutual between the parties. I think, for example, the private company will also have to do due diligence of the ministry or the department or the authority that is entering into the public-private partnership space, right? So I think due diligence is something that has to be complied with. And very importantly, friends, let us apply due diligence in the labor sector. For example, I've spoken about corporate due diligence, then we can talk about financial due diligence, then we can talk about labor due diligence. Now, let's imagine that this is not a greenfield project. Now, most PPPs can be greenfield, but public-private partnership projects can be brownfield projects. Brownfield projects are existing projects. Say the Bombay and Delhi airports were already existing, right? And they were given to a PPP mode for what we call as the operation, maintenance, and development. Right? Development means new terminal can be developed, but to take over existing operation and existing maintenance, we handed over the project to, say, the GMRs and the GVKs. Now, you will notice labor due diligence is also critical and important. For example, today the Tatas have taken over the Air India, right? It's completely privatization. It's not public-private participation. But there are employees with Air India. There would be employees in the airports who are already working, say, for 20 years or 30 years or even maybe a couple of years. Now, the labor due diligence is important in terms of how many people are working, what is the current salary, what could be the existing salaries that will have to be increased over a period of time. Maybe in such kinds of due diligence, you will notice there is an initial lock-in time. Now, to convert the laborers and the trade unions, you will notice that we would probably give them an assurance that for the next 5 years there is a lock-in, that you will not be removed, or you will be absorbed by the new public-private partnership. So that's an assurance that labor always requires. So from completely a government labor setup to actually give it to a PPP labor setup, you will notice that the trade unions will always have some kind of concerns and objections. We have already seen that in the Balco case, where the trade unions also challenged the privatization of Balco, and they said this is not in favor of public policy, especially when labor is adversely affected. So labor due diligence also will be necessary and very important. For example, what are the existing workforce, how much extra would be required, whether extra would be required or not, which are the technical sectors or areas in which labor has to be strengthened, whether they need to be reskilled, whether they can coexist with the existing workforce. So all of these would be also there in a labor due diligence process. So, because public private is a joint venture, due diligence, if done appropriately with adequate care, it could actually result in a very successful implementation of the joint venture between the public and the private space. Finally, you would want to give due diligence to finance in terms of loans, encumbrances that are existing in such a brownfield project, and most importantly, you will finally want to conclude a due diligence on tax matters. Taxation is also very critical. Are there tax dues? Are there tax disputes? Are there tax pending claims? Are there consumer litigations? So that is the legal due diligence that is usually done. So all of these are very, very critical, because that is where the transparency of the transaction will be ensured. That is where proper information can be shared with the other partner. The other partner can actually take a very informed decision in terms of the joint venture that comes into existence. So due diligence helps the process of a better implementation of the public-private partnership space. Of course, there are certain conditions precedent before a joint venture can be accepted, like the foreign direct investment policy. Sometimes the competition regulator called the CCI, Competition Commission of India, under the combination regulations, may have to permit the joint venture to come into existence. Now, you will notice that under the Competition Act, the Competition Commission may have an objection to the joint venture if there are probably two major entities coming together to actually create some kind of a monopoly. It may actually disrupt competition. And hence, under the combination regulation, the CCI may not give an approval to the same. So, just to say that, though you may contractually agree and want to take the joint venture forward, the existing regulations on joint venture, which are not a specific law that we have, but I think there are laws that talk about finance or money, and who can be your JV partner, how can the foreign companies do business in India, they do business through subsidiary model, can they do it through the finance model. All of these will have to be complied with. And yes, of course, there are some regulators who may have to give permission before the joint venture can come into proper existence as well. So if these are complied with, the public-private partnership can be a very good joint venture to actually take the complete process forward. So continuing and understanding joint ventures, consortium bids in a public-private partnership contract, one of the interesting issues that did come before the Supreme Court of India in 2018 is that when does a contract come into existence in a PPP mode? Now, usually in an ordinary government contract, as soon as there is a declaration of L1, we know that the contract comes into existence because the contracting parties are confirmed, and the rest is the documentation process in which, say, the letter of intent is issued, the work order or the purchase order is issued, or the agreement is actually executed between the parties. Whereas in the PPP mode, what is the issue? The issue is, friends, there are two stages of the PPP contract. The first stage of the PPP contract is to confirm the private partner. Only if the private partner is confirmed and the private partner adheres to the preconditions of the tender, only then the concession agreement will be entered by the government with the PPP SPD, that is a special purpose vehicle. Now, what happened in the uh, this was about the Jawaharlal Nehru port case, and in this case there was a request for proposal that was floated, and a consortium of bidders, and please note, I told you this is a consortium bid, it's a joint venture among the private players. This was evaluated, and two companies came together, they participated in the bid, and they were selected. Actually, this was an Indian company along with a Singapore company. Now, this consortium was declared as L1. Now, unfortunately, what happened is that the Singapore company later on withdrew. Now, of course, the Singapore company cannot be under the jurisdiction of India. So this is usually the problem of foreign companies actually entering into consortium in India. And what it leaves it makes the Indian company solely responsible and liable for the execution of the project. But inevitably, because port requires prior experience, port requires prior business purpose, entering into such consortium bids with the foreign companies has become the practice and norm of the day. Now, the Indian company that was left, because the Singapore company withdrew, they actually then said, okay, we'll make another SPV, and we will continue this work. But the port trust reserved its right. They said, look, as soon as you come up with a different, see, we have made you L1 because you tied up with the Singapore company. Now you're tying up with somebody else. We have some preconditions of actually giving clearance of that second consortium player. And hence, the board of trustees of the Jawaharlal Nehru port, they sent this for approval to the Ministry of Shipping, the new consortium that was created. Unfortunately, the Ministry of Shipping, which is the approval authority or the regulator in this space about who can do business into what sector, even including the PPP, who are the private entities, there is, interestingly, you notice vis-a-vis foreign companies, a security clearance also has to be given by the ministry. Because of course, with a lot of these Chinese companies or Russian companies who are trying to do business in this India, security clearance from ministries for any kind of JV or public projects or government public-private partnership projects is a must. So the ministries actually have to give their due diligence before giving such clearance. Interestingly, the Ministry of Shipping did not clear the new consortium, right? And because they did not clear the new consortium, the issue was whether the contract had come into existence, right? So there was issues about arbitration and whether the arbitration was entered into, or was there a clause in an executed contract or not. That was another separate issue that was there in this case. And the tender document had said that the courts in Mumbai alone will have jurisdiction, and tender did not have any mention to the arbitration clause, right? Now, what was there in the tender will be something that will be binding if no contract is made. If a contract is made, what was put in the contract will actually come into existence, right? Now, please note, the concession agreement is the contract. Selection of the private player is not the completion of the contract with the PPP. Selection of the private player is only to clear the special purpose vehicle. It's only to identify with whom the public will partner and who is the private player with whom the public want to partner. So it's not just once the private player is selected, you cannot come into conclusion that the contract has come into existence. The contract will come into existence only when the concession agreement is entered into by the government and the PPP, special purpose vehicle. Right? That is what the court held. So the court held in this case that there was no concluded contract with the port trust, and what was done was pre-contractual. So selection of your private player is completely pre-contractual, and hence probably it's not binding on either of the parties to actually go ahead. They can actually withdraw. That's definitely a possibility. The port trust need not go with this consortium player, the Indian person, because the Ministry of Shipping has not approved the new consortium, which was a prerequisite or a precondition before the concession agreement can be entered into. So please note, in a PPP project, the contract comes into existence once the concession agreement is signed, not when the private partner is selected in the L1 or in the H1 process. So that is something that we'll have to understand, how PPP contracts are different from regular contracts, when declaration fail one is the time and place when the contract comes into existence. Now, just to give you an example of a public-private partnership, friends, the best example I can share is the Bangalore International Airport Limited case. Now, this slide compares the NICE case that we discussed at the very beginning of this chapter. And because the NICE case, as I told you, friends, is a flopped model, it's a problematic model. We learned from the NICE case how it is important to make a PPP project. And then we want to compare it with the BIAL project, which is the Bangalore International Airport Limited project, which is probably one of the successful public-private partnership initiatives in this country, along with Hyderabad and so on. But Hyderabad and Bangalore were greenfield projects, so it started from the very beginning. So it is actually very important for us to understand the same. Now, first of all, if you understand the NICE versus the BIAL process, Please note, BIL and NICE both are private limited companies. They have been registered as private limited companies. However, you will notice that in NICE, the government or the public equity is almost nil. There is no equity of the public. So it cannot be, at least in the special purpose vehicle sense, be called as a public-private partnership project at all. Right? Whereas in BIL, you will notice, if you see the shareholding, current shareholding, friends, it was a shareholding that was slightly different earlier. But in 2016, GVK actually sold much of its stake to a company called Fairfax India Holding, which is actually promoted by a Canadian NRI, a non-resident Indian. And Fairfax is now holding around 54% in BIL, along with Siemens and some of its joint ventures, which is holding 20%. That makes 74% of this Bangalore International Airport Limited, which is a PPP, to be held in the private space. Now, if you again notice, the planning for holding this 74% is critical, because that gives the private player more management and ownership stake to dominate decisions and to run the company. Now, we know that if government holds 51% or more in any company, then it's called a government company. So government has majority holding. Now here you are giving 74%. So encouraging the private player to invest more because you have 74% stake, to take part in the management more because you have 74% stake, to take the liability more because you have 74% stake. Finally, you will also get profit more because you have a 74% stake. But how do you conclude that this is PPP or 3Ps? Is because you will notice two governments, both the central and the state government, have 13% stake in the Bangalore airport. So it is 26% public, 74% private, and this is how the holding of PPP comes into existence in the Bangalore International Airport Limited case, which is registered as a private limited company. It has the following shareholders who have probably entered into a shareholders agreement: Karnataka State Industrial Infrastructure Development Corporation 13%, Airport Authority of India, Fairfax Holding, and Siemens. So this is the shareholders pattern, and shareholders agreement will go through this kind of a pattern. When you compare it to NICE, friends, NICE is completely private. The 100% equity is owned by a private player. There is no public participation in the SM. And now you will understand. See, the point is very simple, friends. If suppose government in Bangalore airport has 26% shareholding, please note the exposure to risk is also 26%. The profits of 26% is also going to go to the government. Right? Whereas in NICE, when you notice that this contract now of a highway which is built around Bangalore is going to be operated and maintained by NICE, and the toll money that is going to be collected is going to the NICE company. Now, what of that toll money goes to the government? Nil, simply because they are not in an equity participation in the company that has been given this contract. So that is where the fault in design of NICE and the lessons learned could be clearly visible in the BIL project, right? Not that this cannot be a PPP model. I'll just come to that in a little while in the Adani's case, how that is done, because Adani's case is not that there is a equity PPP, but it's a concession agreement to which government can earn royalty directly. So that's a different kind of model, but the original PPP model is in this case. Now, the type of business, friends, you will notice is the build, own, operate method, and finally the transfer, that is boot. Which in the NICE case doesn't seem to be there, but in the BIL case, definitely it is something that is very important. Build, own, operate, and transfer. So because it's a greenfield project, right from say the issues on land, identification of land, maybe designing the project, this is called the D-boot model, right? So design, build, own, operate, and transfer. That is a D-boot model. But in the Bangalore case, it's build, own, operate. So the land was already taken by the government. Now, please note, when you saw about government, you will notice that the Karnataka government, how does it invest 13% equity in BIL? It does not literally. What it does, it just acquires land and the land value is taken as equity. It may give a soft loan of 450 crores and so on and so forth, but that's usually how government equity is actually converted into these companies. So on the government land, please note, you will build the airport. You will own the airport. Own means, please again note, it's not an absolute ownership. You'll only own the assets built on the land. The land belongs to the government. You'll only own the assets built on the land. For what purpose? It's not absolute ownership for lifetime. It's ownership during the concession period or during the lease period. And you will own it for the purpose of, say, mortgage, or you charge that has to be done, or maybe you need to raise some money from banks to do the expansion activities. For all that purpose, probably the ownership can be granted. But please note, it is only ownership to that extent on assets built on land that you will be granted that kind of a right. You will operate the airport, which is very, very important on the PPP formula. Operation only on the civilian side, operation only on the passenger and cargo facilities, but not air traffic control nor the security operations are handed over to the BIAL company. Right now, coming to NICE case, friends, interestingly, though you will say it is build, own, operate, the problem with NICE is some of the land in NICE have been transferred to ownership of NICE. So once you have the ownership of land, friends, there is no question of, the only option, if you ask me, is to reacquire that land. Right? Some of the land that were leased, some of the land that have been granted to NICE just to build the road, they can always be taken back. But the ownership of land, once it is transferred to a private player, the private player is not in a PPP mode. He's actually in a private mode, completely private, no equity. Land is his. He just builds the road, and that becomes private road in most sense. And that's why I said NICE happens to be probably the first case of a private road project in this country. And then he takes the toll, and the toll money, of course, he keeps it to himself. Of course, if you look at the toll to the national highway projects, because it's a PPP, that is public, the highway authority also earns from the tolls because there is public-private participation in the same. But that's not the case, unfortunately, in the NICE case, because there is nothing that the government earns from this project, because the government does not have equity, neither it has a contractual right in that kind of infrastructure project. Again, the concession period. Now, what is interesting is, say, some of these NICE projects, if you look at it, the concession time has not been negotiated at all. They say for toll roads, it can be 40 years, right? It's not necessarily 40 sometimes. You will notice that in some of the contracts, it's not mentioned at all. So, NICE case has been completely kind of, not a pre-planned, properly executed, implemented kind of a project. Whereas in BIL, the concession period or the term of this PPP is 30 years. Right? That's the concession time. Now, in the new airports, the term has been extended to 60 years. Long term, giving the private player more time to actually look at it. Right? Was the private player chosen in NICE? They weren't chosen at all. Was the private player chosen in the BIL case? Yes, it was chosen, and the state government also then signed an MOU with the chosen player, after which the concession agreement was signed by the Ministry of Civil Aviation with BIL. That's how the project was actually given shape of. Now, some of the ownership of land in NICE, as I told you, has been transferred to NICE. Some of them have been given on lease at 10 rupees per acre, which is probably one of the most horribly negotiated clauses. And the consortium, interestingly, that is NICE, has also done a resale of some of these land. Yeah, they did it. So, and that's where the government started feeling quite objected, because the purpose of the land that was acquired and given to NICE was for road, and now they are reselling it for something else, and hence some of the disputes in NICE were raised because of these kinds of complications, right? So now the road on which the land is built, friends, please note, the government will have to reacquire the same after, say, the 40 period or whatever period has to be done. So it cannot be easily transferred. Like in the BIL case, please note, the land belongs to the government, you come and build. Now, after the concession period, everything that is built on my land is mine, right? It's an automatic kind of a conclusion, and hence the transfer could be far more easier in Bangalore airport case rather than the NICE case. So this is precisely the lessons that one can learn from NICE and not repeat those mistakes, and probably formulate the PPP project far more structured in a far more better sense to serve both public purpose as well as private interest. Now, if you look at the public-private partnership model, friends, you will notice that there are different models: design, build, operate, maintain. There could be a rehabilitate and operate, maintain. There could definitely be a concession model, and finally, finance, operate, and transfer model. So there are many such models that are existing for the PPP to come into existence. And one of the concession model agreements are, please note, like the current Adani airport cases, where the government is not in the Adani airport. They are not an equity participant. However, the concession agreement very clearly is based on the fact that you select the concessionaire based on the kind of revenue he will generate and pay to the government. So it is going to the Yachwan, right? So the government enters into a concession. It's like any other outsourcing, but you get to build the airport. You get to operate the airport. It's already a government airport with certain piece of land. And based on the traffic projections, you have already told to the government that this is the annual royalty that you will pay to the government from that particular project. To make it profitable, to make it workable is your choice. Government gets an upfront profit. The government need not take part in the management and the equity or the formation of the PPP structure. That's how the concession model operates, right? That's now a preferred model. Rather, you will notice that there is news that the Airport Authority of India will actually divest its stake in the Bangalore airport, the 13% stake that it has, because it no longer wants to, be a participant and take part in the business operation, in the day-to-day management. It may have to appoint one director. So why should it do? Finally, the government should earn. Government must be able to control the activity, and if you can do that even without taking part in the BIAL process or in the airport, special purpose vehicle, then it is a win-win situation even for the government, and it's a better situation for the private player because they don't have to worry about government interference into the board and the management policies as well. So I think right now in the PPP structure, what we have realized is it is important to select the concessioner, enter into a concession agreement. The government need not be an equity player in that PPP mode. That is a free hand that you can give to the private player and make the operations far more efficient and successful as the case may be. Finally, please note, friends, the land on which this concession model of the Adanis are going to be built is government land. It is going to be with the Airport Authority of India, which is the regulator for airports. So when you are going to anyhow do that, I need not take part in the process of establishment of a private limited company. I need not be an equity holder and create more complications. So simpler model is the concession model, and I think that is something that new airports have actually been adopting too. However, you will notice that in the airport sector, some of the airports are still completely public. They are not into the PPP mode, like the Chennai airport and several other airports which are maintained by the Airport Authority of India. Whereas some of the airports are in the PPP mode, which has created a SPV. Some of the airports are in the concession mode. So I think all such kinds of, we are kind of experimenting with the different modes of PPP. We are trying to evaluate which is more advantageous and which is not. And that's how I think most of these public-private partnership contracts are actually moving forward. And I think whatever is convenient, whichever is less cumbersome, whichever is easy to execute and operate, I think that is the kind of model that is being raised. I think the government is looking at developing the infrastructure for citizen-centric experiences and approaches. It wants to execute them in a faster manner so that the citizens are benefited by it. So I think they're focusing on that, time as the essence, simplification as a process, and efficient execution as a management principle. Are there legal issues and challenges to public-private partnership? I think there are some of the legal issues, and I think some of them we can always, take up for our discussion as a concluding part of the chapter on public-private partnership. Now, choice of criteria for the public-private partnership projects. Friends, whenever a tender is called by the government, who does it want to partner with? What are the qualifications of this private consortium or the private entity to take up this PPP project? This is something that can obviously be taken to the court of law through a writ petition, and people can challenge the criteria that have been floated in the tender. So when the tender document or the request for proposals are actually being enacted, I think it's very, very important that the criteria that are mentioned are very objective in character and nature. They are feasible in terms of its approach and fulfillment. While I'm sure the government is very keen to select a private player who should be an Indian company, of course, that is an essential criteria. But you will notice that, say, in the airport sector, Indian companies, when the airport sector was opened up for PPP mode, Indian companies did not have experience in managing airports. And the airport authority and the Ministry of Civil Aviation could not give it to a person who did not have experience in managing airports, because airports are not like highways, they are critical security infrastructure areas. So some experience in management of the airport or building the airport was equally necessary. So what did the government do is that they said, look, we need some experience with the consortium. So let the Indian company be the lead consortium bidder. Let them tie up with, say, Zurich Airport or any other airport company which is already managing airports across the world. Let the consortium participate, and whoever actually gives us the best terms and conditions is the one with whom we will actually tie up for the Bangalore or the Hyderabad airport. Now, the courts usually do not want to intervene in tender conditions, but yes, of course, they can be called upon to test the reasonableness of the tender conditions. And hence, you will notice that in cases like Balco, the Supreme Court has clearly laid down that the criteria of a tender or request for proposal can be challenged if they sound to be quite arbitrary, unfair, and unreasonable, and more importantly, if they are not feasible at all. Right. So, while the concerns of the government can be definitely respected, I think the practicality of the private parties and private persons are something that are also very important for us to take due note and consideration of. Right. Now, you will notice that in some of the tenders, the courts have said that you cannot create tender conditions so as to exclude some parties, right? There are certain very mischievous tender clauses which actually are not inclusive in nature. They deliberately create something to exclude competitive parties from the tender. That, I think, is a problematic situation. So I think tender conditions must be as inclusive as possible, giving wider participation as possible to everyone concerned. And I think that is the tenders that will be least intervened by the courts of law. Otherwise, the courts have a tendency to actually direct what tender conditions have to be laid down. Now, the courts have very clearly said that we don't want to interfere in the technical policy decisions of the government, right? If the government requires certain kinds of technicalities, the government is the best judge to do that. So the courts have also said that. However, I think wherever that exclusions can be brought in, I think the courts have already very clearly laid down what are the criteria for its implementation. Um, Actually, there is recently one case that I was reading. This was about airport handling services. Interestingly, the Airport Authority of India for airport handling services went in for a global tender. And they did not give preference to MSMEs in India. So the MSMEs actually challenged that global tender. They said, for airport management services, is there a need for a global tender and allow more competition from external markets? And when you allow for global tenders, look, the annual turnover that is required definitely raises up, right? You want more turnover of these companies as well. So very recently in the airport case, I think the courts did lay down that it is an exclusionary kind of a tender. It excludes MSME, it excludes local companies. We say local for vocal. We say promote more of MSME, small scale industries in India. We say make in India. We say, Atmanirbhar Bharat. So unless you want to promote Indian companies, please note we are talking of promotion, protection of Indian companies. And you will notice that in a lot of government tenders, 15% of tenders are reserved for MSMEs. They're to protect small scale industries. And here was a global tender that was actually excluding them and taking them away from the competition. And interestingly, in airport handling, for a lot of duration of time, these were the companies that were involved. They're small scale companies and they can actually do those business in tier 2, tier 3 kind of airports and cities. Why call for a global tender to such kinds of cities, airport handling services? Because the traffic is pretty low in some of these cities. So local companies should have been given opportunity. They should have been given priority. And the airport authority unfortunately did not do that. Was an allegation that was put in that case. Right? So I think tender conditions have to be very carefully drafted, and I think it's a matter of public policy and how they can be actually brought into consideration. Coming to the second most important challenge of a PPP is, I think, whether a PPP is a state under Article 12 of the Constitution of India. Look, these projects were state till they were transferred into PPP. These were all state under Article 12. They were amenable to the writ jurisdiction under Article 32 of the Constitution and Article 226 of the Constitution. Now that you make a PPP, it's like putting it at an arm's length distance. It was public, but now I'm putting it into the private, so it's an arm's length distance. And being at an arm's length distance, can we consider this to be, or can it continue to be a state under Article 12, which means then a BIAL in which 74% is of the private will be answerable under Article 226 before a High Court for violation of fundamental right or for the violation of any legal right. And please note, once you are a state, you have to follow all the principles of state procurement and state recruitment, or even state policies, as the case may be, which may be applicable to any government sector rather than those advantages that are there in the private sector. So that's the real broader question. And that question was answered by the courts in this case called the Flamingo Duty Free versus Bombay International High Court, MIAL, right? Mumbai International Airport Limited. Flamingo duty-free shopping versus MIAL. It was a Bombay High Court decision that came in 2008. And there is a parallel case with the BIAL that was decided by the Karnataka High Court as well. And both these High Courts very clearly said that, look, these would be considered as the instrumentalities of the state. Though the state just has 26%, they would still be continued to be held as the instrumentalities of state under Article 12, and that they can be held accountable under the writ jurisdiction of the High Courts. That is something that the courts have very clearly laid down. Also, whether provisions of exclusivity given under the concessional agreements can be considered as anti-competitive, because you are giving them exclusive jurisdictions, right? See, uh, the courts have very clearly said that, look, when you're giving an exclusive right to one person to say do something, it could be the highways, it could be the port, it could be the airport. It's not necessarily to be anti-competitive. It is just to protect his investment. It's just to promote, the project which should have been promoted by the public, but which is now done with the 3PO. So, it is not considered anti-competitive, though it looks to be so. It is just trying to protect that kind of an investment or opportunity that was created, so that some return on investment is assured. Otherwise, if you open up the sector, and even if the government, say, after doing one PPP with an A contractor, suddenly does another PPP with B contractor, then to that extent it will affect the market condition, it will affect the public policy as well. And hence, these kinds of exclusivity provisions are not considered to be anti-competitive. In the BIAL case, this is the Delhi International Airport Limited case. As I told you, it's a brownfield project. Both Bombay and Delhi were actually. And you will notice that the employees of DIAL went to the court, they went to the Supreme Court, and they were looking at their benefits, because once it is transferred to the PPP, what benefits they can continue to have. I've already addressed this kind of a due diligence that could be required. What kind of promises are made to the unions and the employees before such projects are taken over? I think that will become a very critical part of the whole sector. And you will notice that the DIL case was an important case which has helped transfer other airport businesses in other cities as well. And that, I think, has been a great way in which you can ensure the success, and you can ensure proper implementation of the project. Of course, dispute resolution becomes critical. I told you these are long-term contracts. Dispute resolution has to be addressed in a win-win situation. It's not about pointing faults. It's not about pointing mistakes. It is not about finding breach in contracts. I think even if there are some breaches, I think those gaps have to be filled. A long-term plan has to be in place. I think egos have no place in a PPP project. I think solutions are there on the table. There has to be some give and take. And the Double Power Corporation case is a wonderful example of resolution of dispute. We always say arbitration is an attempt to resolve disputes. In an out of court settlement, in a formal mechanism, we call it alternate dispute resolution. Now, the term resolution is critical and important for PPP projects to come into existence. And in the double case, you will notice how that resolution plan was clearly laid down for the Maharashtra State Electricity Board to get involved both equally and in the management structure of Double Power Corporation to make it a successful project, to make it an operationalized project. Otherwise, it would have been kind of, it could have been a monumental heritage kind of a piece with no purpose whatsoever. And I think the government did very good in bringing about a resolution plan in the double case. And I think the same goes to all PPP projects as well. Right. So these are some, just to give you an idea about the issues and challenges in the public-private projects, and where such issues can be resolved, and what kind of policies have been laid down, and what interventions were called in by the court of law is something that you can always take due note and consideration of. Now, to conclude this slide, two issues we can always take into consideration. One is whether the PPP projects are going to be audited by the Comptroller and Auditor General of India, that is CAG. Now, with 26% of shareholding, please note, all the PPP projects will be audited by the CAG, right? From the stage of the time when the tenders were floated to the time the profits are being shared or the accounts are being submitted. So CAG will have the right to audit and account these projects. So there is no problem about the kind of control in terms of accounts, finance and budget that is required from the public or from the state or from the citizen's perspective. This is one part of the advantage At the same time, maybe from the private player it could be disadvantages, but it is a very clear advantage in terms of control of public over private. Second is, while I said that PPP is a state, the other challenge that did come by is whether Right to Information Act will apply to the PPP projects. Now, RTA Act 2005, friends, is something that is applicable to all public authorities, right? And please note, when you look at Section 2H of the Right to Information Act, which defines public authority, it says any non-governmental organization which is substantially financed by the government is also covered under the Right to Information Act. Now, substantial finance means what? Can it be land at a subsidized price? It could be. Can it be equity of 26%? It could be. So, the courts and the information commissions have very clearly gone on to hold that the PPP projects can be covered under the Right to Information Act, and they are supposed to give information under the RTI Act as well, so as to ensure transparency and accountability of the whole process. So citizens can also use RTI to get information about the project called the PPP project.